Good morning. This is the Public Safety Civil Service Commission, and it's 10:03, I think. We're going to call the meeting to order. The first thing we're going to do is have a land acknowledgement. The City of Seattle Public Safety Commission acknowledges that we are on the traditional land of the first people of Seattle, the Duwamish. We honor with gratitude the land of the Duwamish people, past and present. We're going to go through our agenda, which is posted on our website. So the next item is introductions. Before we do this, I guess I'd like to set out some sort of rules about how because our meeting is being recorded, we like to, in order to make the record clear, I'd like to have just one person speak at a time. If you identify yourself when you're speaking, so the record is clear about that, because the recording can't see, it can only hear. If you're not speaking, we'd ask you to mute yourself, because there tends to be sometimes a kind of a feedback problem if people aren't muted. And again, if you state your name before you start talking. So again, the first next item is the introductions. My name is Richard Green. I am the chair of the Public Safety Civil Service Commission. So I think there are other commissioners on appearing virtually. If you introduce yourselves, please.
Hi, this is Stacy Knoll. I am here remotely, and I am one of the commissioners.
Thank you.
Yes, and I'm Tom Applegate. I'm also appearing remotely, and I'm one of the commissioners.
Thank you. And now we have our staff could introduce themselves, please.
Yes, I'm Andrea Sheely. I am the Executive Director of the Public Safety Civil Service Commission. I'm Teresa Jacobs, the Executive Assistant of Public Safety Civil Service Commission.
Sarah Butler, Operations and Policy Advisor, Public Safety Civil Service Commission.
Thank you all very much. So the next item on the agenda is to welcome our new commissioner, Tom Applegate, and we're very glad that you're here. I'm very much looking forward to working with you. Commissioner Applegate, I want to make sure that you understand, anytime you have a question about something or some comment that you want to make, I want you to please feel free to pipe up, to speak up, because otherwise I don't want to run all over people. So I just want to let you know that any question you have, any comment you want to make, I want you to make sure that you feel free to say something. So, but again, thank you for being here. Very much appreciated. The next item on the agenda is public comment. I think we want to limit public comments to 3 minutes each. And again, if you want to make a public comment, if you could first of all introduce yourself, and then whatever you'd like to say. So, is there anyone that would like to make a public comment? All right.
Is there anyone in the room who would like to?
We would.
Oh, okay.
We would like to wait for people online to have the opportunity before us, or at least I should speak for myself. I would like to go after people.
If you are on the call, the meeting remotely, and you would like to make public comment, please raise your hand, your little virtual hand. I don't see any person. All right. Mr. Collins, would you like to come and sit at the table? And I will, when you start speaking, I'll start a timer.
Okay, we wouldn't want to go over time. This is an important. My name is Steve Collins. I am from the Seattle Fire Department. We were all terminated, whether it was a forced resignation, a forced retirement, or actual terminations. I'm here. I've just filed a complaint with Ms. Jacobs about Chief Scoggins and the Seattle Fire Department administration. The last time I was here, I made the claim that you folks were not acting independently. It seems as if you have not taken notice of that yet. Some of our members have filed requests to be reinstated, and you've ignored him. Not him, them. It's been now 6 weeks since Jeff Vale has put in a request to be reinstated. There's ample evidence that the Seattle Fire Department fired everybody without cause, and you have failed to respond appropriately to him. So I wrote a letter to the commission. I emailed it on Monday. I received receipt. This is not going to, we're not going to go away. This has been acted on wholly inappropriately, and I mean, we don't want to be lawyers. We don't want to sue people. But there are significant penalties for not acting correctly. So that's basically the reason. Your charter from your own website and from the RCWs, you are supposed to act as an independent third party, which you're not. You're meeting in secret with Harold Scoggins, Sarah Lee, and Helen Fitzpatrick, not inviting us to the table. You're volunteering information to the fire department administration. We know this through many ways, one of which is public disclosure. We are not, as I said before, we're not going to go away. You can look up Seattle Municipal Code 4.08.040 that provides for a personal, not a public safety penalty, that provides for a personal penalty for people acting outside the boundaries of good faith. Harold Scoggins has fired people based on his personal animus towards religious people. Okay, we're not going to go away. It's the third time I've said it. How do we get on the agenda? Because apparently the only thing that the Seattle Fire Department, how do they send Ms. Shealy an email and she responds to them saying, oh, by all means, let's meet on the 29th of November. Okay, how do we meet with you on the 29th of November or whatever other date? Okay, because this is untoward. This is not appropriate. Okay, now I would like to know how to get on the agenda. We the only thing Sarah Lee, who by the way has a legal degree. I don't know if she's passed the bar or not, but she has a legal degree and she's busy Googling what just cause is. Yeah, so can I finish? It's only short.
She could wrap up, please.
Okay, absolutely. So we want the same consideration that you're giving basically the religious animosity people who have fired us inappropriately. We were not fired. I'll finish. We were not fired appropriately. We followed the mayor's dictate that said the process for a religious exemption to the T exactly, and no one can dispute that. So I filed the complaint today with Ms. Jacobs, and pursuant to 41, I can't remember the number, it doesn't matter. The RCW, where you guys are required to follow up on, and I would like to know at your leisure. I would like to know how you're going to follow up on my complaint, and I'll be finished. I got a lot more to say, but I'll be finished. Thank you.
Thank you very much. Is there anyone else that would like to make a couple comments?
Yeah.
Sure. Yeah, you can state your name, please.
My name is Andrew Pittman, and I'm just an individual. I'll explain a little more here. You want to let me know when my timer starts?
Yeah, go ahead.
All right. Hello, my name is Andrew Pittman. I was wrongly terminated without cause in 2021 in violation of my Title VII rights, along with many other rights and many other individuals for our religious proclivities. I currently have a request for reinstatement pending. This commission and SFD appear to be trying to keep me and others who were wrongfully terminated out of SFD. The delays of this commission are yet another tactic that illustrates to me you are not an independent body and are acting on behalf of SFD. The typical reply for others applying for reinstatement has been about a week or so. This is based on my public disclosure requests. The timeline that was discovered by me seems to be much faster for others, but it is not the same for people like myself or others asking for reinstatement who spoke out against Scoggins and the illegal firings. The commission created a portal for us to apply for reinstatement that is substandard. My life and my career are on the line, and the portal doesn't allow me to include attachments. When I tried to address this via email with Andrea Shealy, I got no response. Jeff Bale has been waiting over 5 weeks for a response from this commission, and the commission said they are waiting on SFD to get confirmation of his separation type. All of these records were requested and delivered from SFD to the commission last spring when we originally asked for reinstatement. I also have the PDRs to verify all of this. This process is looking like as big a sham as the COVID vaccine directive that was used to fire us those of us with protected religious rights. I encourage the city attorneys, I emailed them this morning to try to get them to chime in on this, who are here today, some of you online, to advise these unfaithful actors to start upholding the responsibility that is expected of them and thereby reduce the liability they're putting on the community that they serve. I'll use the remaining time to say that I find it very interesting today that we're talking about public disclosure requests and public meeting standards when we've been asking for these very things to be done the entire time. I'm a high school dropout that likes running into burning buildings. It's pretty simple. I have a religious belief that got me fired. I still want to go running into burning buildings, and I bet you if your house was on fire, you would want a guy like me running in, because unlike most of the people here, I commit to my job, and I'm committed to doing what's right. And what is right is written in black and white. You guys will be discussing it at the end of the meeting today. And it's already been stated, there are CWs that protect all of this. So it's never too right to admit you were wrong. It's never too right to change a course. And at this juncture, all we ask is for our jobs to be given back so we can go running into burning buildings. Some of the people that are on here today are as close to family as I've got. They're my coworkers. They're not people that come into an office here. They're people that are willing to die in a fire with me. They're the people that are listed on the documents that if I die in a fire, they're to contact my wife, not Chief Scoggins. Because there's a level of trust that's earned by running into burning buildings with each other. Thank you for your time.
Thank you. Anyone else, either in the room, want to make a comment or remotely?
I see Brent Matilla
Right.
has requested.
Can you hear me?
Yes.
Great. Yeah, I don't know how to raise my hand on this, so I put a comment in there. So I just want to make a public comment. My name is...
You could identify yourself, please.
Yep, that's what I was starting to do. Start again. My name is Brent Matilla. I also was fired by the Seattle Fire Department. So I was on leave until December of 22, and then I was fired in, I believe it was the end of January of 23 or beginning of February of 23. The mandate for which I was fired for was lifted. The mandate no longer existed. It was no longer a requirement to be vaccinated. I applied for reinstatement with the PSCSC. It was denied by Ms. Scheel. I appealed that, and at the PSCSC hearing for my appeal to the reinstatement, that also was denied, and I'm trying to figure out how that was denied. I was never given an explanation. I got to make my case, and that was it. I never received any information other than my appeal was denied. My contention is that I was fired, specifically it says, for violation of the policy, but I have an approved exemption to the policy. I have a religious exemption to the policy, and yet they fired me for that. I'm trying to figure out how that works. I was hoping that you folks could explain that to me. I think that's what your sole purpose is to rule and to look at matters like these and say, hey, oh, Seattle Fire Department, they kind of messed up. They fired somebody for a violation of a policy, and yet this person has an exemption to the policy. So in my pea brain, I'm adding up the numbers and they don't add up. So I was hoping that you folks today could explain to me how it was that in December of 22, I was fired for violation of the policy, which was the vaccine mandate. And a month later, that policy was lifted, no longer required. After I applied for reinstatement, the mandate was no longer there. It should have been a very easy decision to take a fully tenured, experienced lieutenant in the fire department and put him back in operations, and it would have been a win for the citizens and it would have been a win for the department. And yet, when you folks ruled on this, whether my appeal to be reinstated was valid or not, you ruled no, and I'm still trying to figure out. I had an exemption to the policy, and yet you allowed me to be fired for that. So please, if you guys could take the time to explain that, I sure would appreciate it.
Thank you. Looks like Sarah Lee, you want to make public comment?
Yes, I will just make a short public comment. The folks that are speaking today, I just want the commission to know are all plaintiffs in a lawsuit against the city. It's the United States, in the United States District Court. Case number 2.23 CV 01095. So with that in mind, the department isn't going to be making any type of substantive comment. Just wanted to let the council be aware that this case is, and the subject matter is part of active and pending litigation.
Great, thank you. Anyone else on our call would like to make public comment?
I would like to respond to Ms. Lee.
Actually, that's not really, I mean, this is not sort of a back and forth.
No, I get that, but she wanted to make the point that we were all sub-litigants. She is the point of that litigant, because she has acted with personal animus. She had, and so she is, as we speak right now, speaking on her behalf in defense of this lawsuit.
Anyone else with public comment? Right. Oh, there's a hand.
Good morning. Can you hear me?
Yes.
Hi, I'm Lance Fisher. I'm back to work with Seattle Fire Department. I work at Ladder 6 up on Queen Anne Hill. I was forced to retire on March 1st, 2022. I had a ladder mill hearing and I was given the choice to retire or be fired 3 days hence. And I chose retirement. So when I put in for reinstatement in early 2023, I was the only one who was separated from service and was allowed to come back because I fit within the confines of the old rule 10.03, which allowed only retirees or resignees to be reinstated. So PSCSC has since changed that rule in what appears to be a specific effort to allow people like Pittman, Vail, and even Collins to come back. They changed the rule so that anybody who wasn't fired under disciplinary conditions could come back. And SFDHR director Sarah Lee came to and logged on to the PSCSC meetings, and I believe it was November, to argue that we were fired for cause and that it was discipline. In spite of the fact that everybody on this lawsuit, I'm part of the lawsuit, by the way, even though I'm currently working for Seattle Fire, I'm the only one who was allowed back. And so, yeah, Sarah Lee argued that it was for discipline. And yet we all have letters that indicate that we were being initially recommended for separation for non-disciplinary reasons. And the fourth floor on SFD's headquarters, the administrative heads, with the exception of Sarah Lee, have all maintained that we were let go and forced to retire for non-disciplinary reasons. So the path is clear here, right? What Harold Scoggins is doing at the fire chief level, he has required firefighters to do drill school over, in spite of the fact that he brought me back with only a 2 weeks ops refresher. So he's using process to disincentivize people from coming back. And now it appears he's just using delay tactics to prevent Jeff Vail from coming back. So the PSC, I believe, has the power to compel the fire department to do the right thing and to expedite these requests. So my request is for the Civil Service Commission to begin using the powers that you have in the law and do your job. Thank you very much. That's all I have.
Looks like one other person wants to public comment.
My name is David Dolan, and can you hear me okay?
Yes.
Okay. I'm assuming you were referencing me with, I figured out how to raise my hand. So,
So I missed 28 minutes.
Since this is the period for public comment, it is my understanding that the formative language surrounding how the Public Safety Civil Service Commission, as I've read it, I don't have it in front of me, but as I have read it and understand it, it calls very specifically for the Public Safety Civil Service's responsibility being to make sure that all rules and laws are followed. And since now, I also understand that that the commissioners' roles rotate. So I don't know if any of the current commissioners were part of the Public Safety Civil Service Commission during the second half of calendar year 2021. If you were not, then basically what happens is you've been handed a poop sandwich that the previous people gave you because they didn't do their job and make sure that all of the rules and laws were followed. Now, we have brought this, our group, the dismissed and fired and resigned and retired firefighters, we've brought this to your attention, trying to do so in a respectful fashion. And now we're finding that, hey, we're having to get very direct, that there's rules, we have them, we've seen them, we've read them, and the people that were at the helm of the Public Safety Civil Service Commission were one of three categories. They were either incompetent because they didn't do their job, they were in collusion or corrupt because they didn't do their job, or they didn't care.
Then they'll catch me. You guys are doing.
And stop. There's some background noise going on. Can you guys still hear me okay? I got another, it's somebody else's mic is on. Hello?
I can hear you.
Okay. So, now in charge of the Public Safety Civil Service Commission. I understand that Mr. Applegate is brand newly appointed, but you have the opportunity, because we brought it to your attention, our group has brought it to your attention. You need to correct this, and the correction is not to rehire. The correction is to recognize that what happened was illegal and immediately reinstate everybody to their previous position. That's reinstatement. That's not a rehire, hey, start over. That's whatever spot you had, you go right back to it.
You wrap
Because
up.
it was, I conclude. Thank you.
Thank you. Is there anyone else who wanted to make a public comment?
I would like to.
Oh, sure.
My name is Amber Pittman. I am a wife of a member who was fired, and I would like to make public comment, partly regarding the comment that Sarah Lee made. I'm not understanding why you guys are not acting as an independent people, an independent body, because the way she's bringing it up is that because they're in a lawsuit that she is also involved in, that somehow that changes your role as the PSCSC. Your role is to represent your members and protect the public, not to be in cahoots with Seattle Fire, not to worry about what litigation is going on, not to listen to her. You have your own role. You are an independent body. You need to be acting as such. Which brings me to my next point. You also represent Seattle Police Department, and those members are getting their jobs back. Some of them are already back to work, and they're receiving bonuses for returning to work. So what is the discrepancies between Seattle Police Department and Seattle Fire Department? Why are these people being discriminated against when you have the power to return them to the register? And you're choosing not to. You're playing the game with Seattle Fire.
No, I get all candy.
And it's completely unacceptable. You're allowing them to make the decisions that you should be making. These people deserve their jobs.
Yeah.
Thank you very much.
Where's a monkey pedal? Then we'll have to walk across the bridge, okay?
There is a caller who we're gonna try to mute that caller. Oh, there you go. Okay.
Anyone else that would like to make public comment? Okay. All right, that will end our public comment. The next item on the agenda is the approval of minutes. And I've had a chance to look at the minutes of the December 14 meeting, and they certainly appear to me to be correct. Again, thank you, Ms. Jacobs, for your work on that. I would move that we accept the minutes of the December 14th meeting as distributed.
This is Commissioner Knoll. I second that.
Okay. Any discussion about the minute? Okay, all in favor say, all in favor of approving the minutes say aye.
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 Okay, so the minutes are approved.
This is for
Okay. So the next, let's see, the next item on the agenda is the meeting schedule for 2024. These are generally like on the, is it like the third Thursday of the month? Is that what
Yeah, I'm happy to give a little speech about this. Okay. So at page 5 of your materials is a proposed meeting schedule for 2024. We do regularly try to meet on the third Thursday of the month, and I've spoken with each of you commissioners, and that generally works. But there, you'll note here on some of the dates, there are a couple of designations. When there's a meeting not on the third Thursday because of a scheduling conflict or other need, and then the little hashtag symbol indicates potential exam protest appeals. Those dates need to be scheduled in accordance to when either when the register needs to be published, or these are for promotional registers, either the register needs to be published or the exams administrator needs to get back to candidates to let them know that they are proceeding on to the next phase of the promotional exam. And so hopefully you commissioners have had enough time with these materials to look at the schedule, and we will be able to vote on and adopt this today or make any necessary changes. I will say the following pages, pages 7 and 8 include the exam schedule as well. And there's one point that is a little different than the schedule, and I will correct, is that we don't need to have a meeting on April 18th. We were able to consolidate those two potential exam protest appeal dates to be heard on April 24th instead. So we may have two separate promotional exams that may have exam protest reviews to be heard, or we may not. It just depends on what happens. I don't think we're going to have questions during this part.
We're looking for the rest of the pack.
Oh, I don't.
They were not available.
Oh, you need a copy of the packet? Sure. Sure. Yeah.
When would it be appropriate to ask a question?
I don't think we're going to have a question and answer session as part of this meeting, but you're welcome to email.
Nobody ever answers my emails. So I mean, I don't mean to make a big deal about it, but the fact is that this is our only opportunity to ask any questions. So I mean, I'm willing to wait, but I'd like the opportunity to answer questions.
Okay, well, I think we're going to proceed through the agenda. Commissioners, do you?
I think Mr. Levan has his hand up.
Okay, Mr. Levan, thank you.
Yes, this is Joe Levan, the legal counsel for the commission. So regarding the schedule, commissioners, just to consider before you take action on this, the way your bylaws are written, as you probably know, it talks about adopting a schedule and then posting that on the website, which is what you'd be doing today. So the ones that are what you would be adopting today based on the schedules in your packet, I presume would be your what you would intend that to be your regular meeting schedule. And as we'll talk about today in our training for the Open Public Meetings Act, there's a difference between a special and a regular meeting. So you would be adopting your regular meeting schedule through a resolution. I recommend you do it through a resolution based on the schedule that's been provided, unless, if you want to tweak it, you can. And if you did so, then there's a reference in that description about there's an asterisk and it says a special meeting not on the third Thursday. So if you adopt this schedule, though, those asterisks, those wouldn't be special meetings. Those would be part of your regular meeting schedule, just to clarify that, because you'd be adopting this as your regular meeting schedule. And that'd be consistent with what the bylaws provide for on how to do this. And then in the future, if you need to adjust any of those meetings, you could do so through special meetings. So any questions on that procedure?
So are you saying we should have a schedule of regular meetings and then take off the special meetings and then?
He's saying if we adopt the proposed dates, that will be our regular meeting schedule.
Exactly, right. So I just identified that because there's reference in the packet to with an asterisk saying these are special meetings, and what I'm saying is those would not be special meetings. You'd adopt this schedule as your regular meeting schedule. So those would be your regular meetings. And then in the future, if you needed to make any adjustments, those would be regarded as special meetings. But this would be your regular meeting schedule, which you would adopt by resolution or by motion.
Okay, thank you. So do we need now a motion to adopt this as our regular meeting schedule?
Yes.
Some discussion with the other commissioners.
The other commissioners, do you have any concerns about these dates or anything?
This is Commissioner Knoll. I reviewed and the dates look great for my schedule. And so I appreciate the advance notice and it looks good to me.
And the meeting dates do continue on.
Yeah, and this is Commissioner Applegate. The schedule also works for me, and thank you for putting it together.
Okay, so I will move that we adopt these dates as our regular meeting schedule. Is there a second?
I second that.
Thank you. Any further discussion about this? All right, so all in favor say aye.
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 Okay. All right, that is passed. So now the next item on the agenda is executive session. Do we think we need an executive session today?
As legal counsel, I'm available if you need to have an executive session, but it's up to you, the commissioners, whether or not you feel that there's a need for one.
I don't see the need for today. If other commissioners think that we do,
Sounds like no.
sounds like we have. All right, so that can be. We can cancel that today. The next item on the agenda is updates and discussion. The first item is the Open Public Meetings Act and Public Records Act training. Joe Levine is here to provide that.
Yes, and I'm sorry I'm not with you there personally. I've had knee surgery earlier this week, so I'm still recovering from that. So if you see me grimace, it's not because of the topic, it's because of the pain of me moving around. So I'll try not to move around very much. So I'll be sharing my screen here in a moment. The training today, I'm going to do the Open Public Meetings Act training, and I'll refer to it as OPMA. And then Aaron Valoff, who's also in the City Attorney's Office, we're both in the Government Affairs section of the City Attorney's Office. He'll do the public records part of this training today. So you'll have training both on the Open Public Meetings Act as well as the Public Records Act. And I see that Commissioner Caesar from the Civil Service Commission is also participating, which is great to get the same training because it relates to the work for that commission as well. And hopefully in terms of today's topic, you've already received the onboarding training related to these topics as a kind of a high level. So today we'll go in more in depth than what you received previously, and then I'll always be available in the future for questions. Also, as a resource, I will provide to you in PDF format the presentation, so you have that as a resource following the presentation. So you don't need to take a bunch of notes today on what we're talking about, but you'll have that available to you. I want you to also keep in mind that I am legal counsel for the commission, but today's discussion is an open session, and so what we're going to be talking about in open session today is not attorney-client privilege, not intended to be attorney-client privilege, both my presentation and Aaron's presentation. So if there are topics that come up that we need to address in the future in executive session as attorney-client privilege, we can do that. But today's discussion is not an attorney-client privilege conversation. So with that, I'm going to share my screen and get the presentation here for you. And I'll ask to confirm that it's working. Okay, can you see the presentation?
Yes.
Okay, and then can you see that first slide there?
Yes.
Okay, all right. So let's begin here. Okay, so the first thing I want to start out with is just to emphasize the importance of what you do, and thank you for your service, because as part of giving this training, we'll be talking about some do's and don'ts, but it's really important to recognize that the work that you do for the city is very important, and we really appreciate your service. And these are laws that apply to you that you need to comply with, but it's also important for you to know that, it's important for you to know that we really value your service and the work you do for the city. The purpose of today's training is to focus on the Open Public Meetings Act, and in particular, this training is tailored for commissions, boards, and committees. And so, I've thought through some of the questions that I've received in the past related to such bodies. So I've tailored it for that. There are a few slides that I'll skip through because they're not directly applicable to this commission, but otherwise, all the materials directly applicable to you all. And to summarize, to crystallize what the Open Public Meetings Act is all about, if you were to say it in one sentence, meetings of the City of Seattle's governing bodies, which include this commission, must be open to the public unless exceptions apply. So why are we doing this training? Because you are members of a governing body under the OPMA. That's a term of art. This training is mandatory within 90 days of taking the oath of office or assuming duties. You've already, again, received some training through your onboarding process, but this will go more in depth. Refresher training is required every 4 years. And also there's transparency obligations, which we'll talk about a bit, related to the OPMA and its declaration of purpose. So just to kind of go back to first principles, it's important to think about the OPMA. It was adopted in 1971 as an initiative of the people. And so it's a very important law in our state that was initiated by the people. So and the legislature sets forth very specifically the OPMA's purpose, and it's in RCW 4230.010. And what I've done is I've highlighted in yellow some significant updates that were made in 2022. There was a few changes made to 2023 that are not important for our purposes today. So, but I have highlighted some changes from 2022 that are important to note, and I'll make note of those. But in terms of that statement of purpose, so all public commissions, boards, councils, committees, subcommittees, and all other public agencies of the state exist to aid in the conduct of the people's business. Their actions are to be taken openly, and their deliberations are to be conducted openly. The people of the state do not yield their sovereignty to the agencies which serve them. That's the statement of purpose. And continuing on, the people do not give their public service the right to decide what is good for the people to know and what is not good for them to know. The people insist, and again, this the part that's yellow is what was added in 2022 to further emphasize the importance of transparency. The people insist on remaining informed and informing the people's public servants of their views so that they may retain control over the instruments they have created. For these reasons, even when not required by law, public agencies are encouraged to incorporate and accept public comments during their decision-making process, as you've done today. So in terms of potential consequences for violating the OPMA, I like to kind of start out with this not as a scare tactic, but just so you know that there are provisions in the OPMA that are important to be aware of in terms of violations. So as a general matter, OPMA violations can lead to, just as a practical matter, we kind of think about this more from a higher level and important principles. As a general matter, the OPMA violations can lead to a loss of public trust in the city's commitment to transparency and open government. So in terms of what the OPMA says, any ordinance or resolution or rule or order or directive adopted at an illegal meeting would be null and void. OPMA violations could also potentially serve as a basis to remove a member of a board, commissioner, committee from that governing body. And there's also fines that could be applicable in certain circumstances if there's a knowing violation of the OPMA. And that's why we're having this training, and that's why I'm available for questions today and going forward at any time. So because it has to be a knowing violation, but it's a $500 fine for a first violation, $1,000 for any subsequent violation. And this is important because it's important that this emphasizes that you all are responsible to know what these provisions provide for. But again, I'm always here to help you navigate the waters related to the OPMA. So an important initial concept related to the OPMA is what is a meeting? And that would be obviously a meeting of the commission. So a meeting, not too helpful in terms of the definition in the OPMA, means meetings at which the governing body takes action. And so then the question is, what is action? But in practice, let's talk about this kind of more as a practical matter. A meeting is a gathering of a quorum, that'd be a majority. So it's two or more of you. And at such a gathering, the participating members of the governing body have the collective intent of transacting the business of the commission. So by extension, key questions to consider are related to what is a meeting? Is there a quorum of the commission participating in the gathering? And if so, do those members have the collective intent to transact business on behalf of the commission? So I'll talk about some of this a little more detail going forward here about why I'm focusing on some of those terms as terms of art. In terms of further considerations, the OPMA can apply even if a quorum of the governing body gathers by email, telephone, or video conference. If the prerequisites for a meeting are present, such as including a quorum with the collective intent to meet, the gathering is a meeting on the OPMA regardless of how it is entitled. So sometimes you'll have regular meetings, you'll have special meetings. We'll talk some more about those. Also, you may have retreats, workshops. It doesn't really matter what the name of it is, but it's still considered a meeting of the governing body, which is the commission in this circumstance. So the key concept, another key concept is action. What is action? So action means the transaction of the official business of in this case, the commission. It includes, but is not limited to, receipt of public testimony, deliberations, discussions, considerations, reviews, evaluations, and final actions. And also I have a note there that the requirements of the OPMA can apply even if the commission is not taking final action on a matter. So even if you're not voting on a matter, obviously, you can still be taking action on a matter in terms of the way the definition of the OPMA in the OPMA. Final action, what does that mean? Final action means a collective decision or negative decision or an actual vote by a majority of the commission on a motion, proposal, resolution, or order, ordinance. You don't have ordinances, but motions primarily is the way you operate. Final action can also occur via, so in this case, I do have references to subcommittees. You won't have subcommittees because you only have 3 members. So two of you constitute a quorum, then that's a meeting of the commission. So you don't have subcommittees. So we can disregard the references in these slides to subcommittees. But other like the city council obviously has more than 3 members, and there are several other commissions and boards in our city that have more than 3 members where they could potentially have subcommittees that are smaller than a quorum that the OPMA wouldn't apply to them in the same manner as it does to the full commission or full governing body. Secret ballots are prohibited. Final action must occur publicly in open session, and final action has significance as well related to public comment requirements, which we'll talk about some more. Now, there are two basic kinds of meetings under the OPMA, and only 2. it's either a regular meeting or a special meeting. So a regular meeting are meetings with are recurring. So regular meetings are recurring meetings held in accordance with a periodic and fixed schedule established by bylaw, or rule, or motion. So that's what you just did. You just adopted your regular meeting schedule for 2024, which will be posted on the website. In terms of requirements related to regular meetings, and some of these requirements, I'll go through them fairly quickly, but Andrea and Teresa are quite familiar with these requirements, and they're the ones who I work with and work with the chair to make sure that these requirements are met related to your meetings. But I just want you to be familiar with them. So the agenda must be posted online to a city website 24 hours in advance. And for a regular meeting, the agenda, and this is an important distinction between a regular meeting and a special meeting. So for a regular meeting, because this is the regular meeting schedule that is posted, the notice requirements aren't as they're not as extensive as it is for a special meeting, and it's not that it's extensive for a special meeting, but they're just different. Because the idea is the public is aware of these because it's on a regular schedule adopted by the commission, and it'll be on your website. So the agenda is published 24 hours in advance, but it's important. You can modify the agenda at a regular meeting, and you can actually take action on items that have been added to the agenda. As a best practice or as a general practice, that's generally depending on the circumstances, not the usual way to do things, because then the public wouldn't have advance notice of that action, but it is allowed under the OPMA to do that for regular meetings. And then public comments, there are no other restrictions on legally transacted business in a regular meeting, and public comment may be required. I have an upcoming slide about that. Related to special meetings, so again, special meeting is any other type of meeting of the commission, which is not a regular meeting, and it may be called by the presiding officer or by a majority of members of the commission. So for example, in that circumstance, there's the way that those generally happen is that Andrea would send out a message saying we need to have a special meeting this month, and these are some proposed dates. And if the commissioners would respond and say, okay, I'm available on that date, and then then notice would be provided related to that meeting. And keep in mind, as we talk about, as I said before, if 2 or more of you are involved in communication about commission business, that would be regarded as a meeting of the commission. So you don't have those kind of communications via email or otherwise, except this is an exception where you can do this to determine whether or not you're going to have a special meeting, where you can have all 3 of you can be involved in a communication about whether or not to have a special meeting and when that meeting will be. So that's the point there in the last bullet point. Additional information about special meetings. So notice for a special meeting must be provided at least 24 hours in advance. A key difference, which we already just talked about, is that, I mentioned that for a regular meeting, you can add items to the agenda and take action on those items. For a special meeting, it's more limited, meaning that final dispositions or final action shall not be taken on any matter that is not included on the agenda that is published 24 hours in advance of the meeting. So, for example, you could add something to the agenda for a special meeting, but you couldn't take action on it if you added it, because if it wasn't on the agenda 24 hours in advance. So that's a big difference between a regular meeting and a special meeting related to what you can do based on what's on the agenda. An important distinction. This is some more specificity about kind of how the notice happens for a special meeting, which we don't need to go too much in depth on. Again, I work with Teresa and Andrea on these, and the chair does about what the provisions are, but it's in writing, states the time and place of the meeting, states the business to be transacted, which is the agenda, and there is a limited exception. And in terms of the special meeting notice requirements, it's so that these requirements are not required if the special meeting is called to deal with certain emergencies and certain circumstances, or when the required notice cannot be posted or displayed with reasonable safety. So, for example, if there's some kind of earthquake or something. In terms of what the notice must provide, it's provided to each member of the commission. It's provided to local media that have a request on file to be notified. It's posted on the city's website, and it's posted otherwise. So again, we don't need to get into all these details, but I just wanted to make you aware of them. Now, a key concept separate than this, but it's very important, is the idea of rolling or serial meetings. Hopefully you've all heard of this. So such a meeting, this would be a meeting of the commission, can occur if action is taken by a majority of the commission, even if the members are not in the same place at the same time. A key consideration is whether the members have a collective intent to meet to transact the governing body's business. Communication exchanges between the commission on social media as well can implicate the OPMA. So we'll talk some more about how this plays out in practice, but one clear way that this can happen is if there's an exchange between two of you related to commission business through an email exchange. Again, that could be considered a meeting. So you don't do that. But there is way you can communicate, and that's this last bullet: passive receipt of information is acceptable. So I'll talk some more about how that happens. It's basically a one-way communication that you're providing information to other commissioners. So in terms of kind of how this plays out in practice, there's a couple court decisions that have helped explain how this actually is considered by courts. One came from Citizens Alliance v. San Juan County, and I put a site there for you. Basically, to summarize, the commissioners there, it was held not to be a meeting, even though there was a six-member county commission or county council that had 6 members on even number, which is kind of odd, but it did. And there were 3 of them that were involved in the subcommittee. So that's so it's 3 of the 6. So that wasn't a majority. But what it said is the commissioners were not aware. I think, and at one point there was one other council member, at least, that was involved in the communication. But even in that circumstance, the court, given the specific facts on that one, held that it was not, based on that situation, was not considered to be a meeting because there was not a collective intent to meet to transact the governing body's business, and there was a passive receipt of information. So again, we'll talk some more about what that means, but that's I wouldn't overread that particular case because it was based on the specific facts. Another case where the court held that it was regarded as a meeting is Egan v. City of Seattle, also involving the City of Seattle and the Seattle City Council. And in that situation, it involved multiple communications between council members over a few days, including in-person meetings and emails and phone calls and text messages about the distribution of a press release. And in that circumstance, there were a majority of the council members were involved, and the court held that was a meeting, an illegal meeting under the OPMA. So that's an important consideration. Again, it doesn't matter, if you're in the same room at the same time, but these can happen through phone calls or emails, even over a few days, if it's related to a topic that relates to, in your case, the commission's business. So in terms of this slide, that doesn't apply because this has to do with drafts. If you're working on draft documents where in some circumstances, if you had more than 3 members where a quorum was more than 2, you could have a smaller group of a committee of you working on a draft together that wouldn't be a draft. It wouldn't constitute a meeting of the commission, but since you only have 3 members, that wouldn't apply. So this is not something that would directly apply to you, but if we get into situations where there's drafting that's happening, where you're considering drafts, generally what's going to happen for this commission, it's going to happen all in open session, and you'll be provided with those drafts as part of your meeting packet, and you'll consider those in open session, and discussion will happen in open session. In terms of some practice tips related to serial meetings, so passive receipt of information via email is permissible, but work from the presumption that discussion of issues via email by a majority of the commission constitutes a meeting. When I say passive receipt of information, so for example, if one of you wanted to say there's some information related to a topic on the agenda you think is really important for the commissioners to consider before the next meeting, you could send that to them and say, please take a look at this article before the next meeting. But to make sure there's not an exchange of communications about that particular topic, because it does relate to commission business. So you could send an email to a majority or more of your colleagues when the message is to provide only documents or factual information, such as emailing a document to all members for their review. But if you want to provide information or documents via email to a majority, so in this case, just 2 of you, sorry, I'll go back here, especially regarding a matter that may come before the body for a vote, have the first line of your email clearly state, for informational purposes only, do not reply. So I recommend you include that at the very top of your email to any emails you're sending to your fellow commissioners. And this just relates to your fellow commissioners. You include that so that they know not to reply, just so it's very clear up front that you're providing this for informational purposes. And you can certainly communicate that way. But the problem is when you have an exchange of communications. So say if you did that and then one of the commissioners respond and say, I think it's a great idea and here's are my thoughts, that's what you don't do. So it's but you can communicate in this manner by providing informational purposes only. Some additional practice tips. Unless for informational purposes only, this is just to reiterate what I just said, don't send an email to a majority of the commission, and don't use reply all. That's really important. Don't use reply all when the recipients are other members of the commission. Another way to do this is you could, instead of emailing the materials to your commission colleagues, you could have designated staff member email documents or provide hard copies to each member. So you could work with Andrea on that because she's not a member of the commission. And a staff member can also communicate via email with members of the governing body in preparation for a meeting, obviously, which is what happens. But the staff member needs to take care not to share any email replies with the other members of the commission as part of that email exchange, because again, this relates to commissioners having an exchange of communications about commission business. So turning now to a different topic but related to your meetings. So meeting formats, there's, in terms of what's required, so a physical meeting location is required absent an emergency. In-person attendance must be an option for the public, and all commission members can attend remotely if the bylaws allow, which yours do. So remote attendance is an addition to, but not instead of in-person attendance. So if remote attendance is allowed, which it is, it should be free, and so that you can't charge for it. It says free, that's what it means. You can't charge for it, and offer real-time observation and participation, and allow for telephonic or electronic means of access, which is the commission's practice. In terms of public attendance at meetings, so in terms of the commission, what you cannot require in terms of public attendance is that attendees register their name or other information. So if you can ask them to identify themselves, that's fine. But if a person says that I don't want to do that, they don't have to do that, and that's important to know. So they don't have to, and they don't need to register in any way. You could ask them as a courtesy to sign up, but again, you can't require that. Sometimes that can really help facilitate a meeting, because then if there's several commenters, for example, then there's a certain order, and you respect the order of the way people signed up. So that'd be the reason to do that. But you can't require them to identify themselves by name or where they live, for example, or to fill out some kind of questionnaire or something. And this is, in the past, there's a reference here to a bullet about attendees. You can't require them to provide their mask or vaccination status unless required by law. That's something that was a question previously when the vax mandate was in place, and if it comes back into place, then that'd be something to consider, but it's not something that's at issue currently. So, but what you may do, you may adopt generally applicable conditions determined by the commission to be reasonably necessary to protect the public health or safety, or to protect against interruption of the meeting. Because again, it's important to realize and to emphasize that the public comment, for example, is important, but these are the commission's meetings for you to conduct the commission's business. So it's the meetings are not, it's important that you have transparency and open to the public, but it's for the public to see what you're doing. But it's not for example, for the public to hijack your meeting so that you can't get your work done. In terms of public comment, some other requirements and conditions and thoughts. And part of this, some of those changes that were made in 2022 added some additional kind of considerations related to public comment. So it's required for regular meetings at which final action is taken. So all that's important. So we're talking about regular meetings at which final action is taken. And I have a decision tree on the next slide, which helps kind of provides more detail on this. That is a good resource for the future. So the governing body is authorized to deal with interruptions and is not required to accept public comment that renders orderly conduct of the meeting unfeasible. So there's a coming slide about that. That's again important. Again, it's you're available. The public is there to be able to see what you're doing, and if you have public comment that's allowed at a meeting, you allow for that. But it's not a situation where it's not permissible for the public then to not allow you to proceed with your meetings. And there's certain requirements related to that, or statements in the OPMA about that. This decision tree, again, I put it in these slides for you to have as future reference. We will not go through it in detail today, but it's a good reference kind of for when is public comment required based on the kinds of meetings. And again, it applies to regular meetings and when final disposition is taken. Okay, just a couple last points about public comment. Except in an emergency situation, oral or written public comment is required prior to taking final action at a regular meeting, as we just said. So oral public comment, if it's allowed, so it's not, and generally the way that the commission is operated is you always allow written comment, obviously, to come in at any time to the commission, and that's provided from the public to the commissioners. And you can allow oral public comment at meetings, and that's been your tradition. You don't always have to do that, but you certainly can. And so if you do allow it, you may limit comment to items on the agenda. You may place time limits on speakers, like the 3 minutes that what we talked about, or which occurred at today's meeting, which is your standard practice. Upon request, you shall, when feasible, provide people with a disability or limited mobility or another reason making physical attendance difficult, the opportunity to make oral comment remotely. That's just something to be aware of. And in terms of written public comment, so you may limit comment to items on the agenda. Written testimony must be distributed to the governing body, and the governing body may set a reasonable deadline for submission of written testimony before the meeting. So that's part of the Open Public Meetings Act. Now, switching topics, and I've got a few more slides here. Another important concept is an executive session, and it's something that goes on the agenda today that we didn't need to have, but it's something that's always an option for the commission to have an executive session as part of your meetings. So what an executive session is a confidential discussion between the commissioners, and most often it occurs with legal counsel to discuss legal risks or actual litigation or potential litigation. So it's confidential with or without attorneys. It must be part of a regular or a special meeting. But for example, you could have a special meetings for the sole purpose of having an executive session. It's only allowed for the specific purposes that are set forth in state law, which is RCW 4231.10. And it's not the same as a closed session, which we'll talk about briefly coming up here. In terms of some additional thoughts on executive sessions, so the purpose of the executive session and the time it will end must be announced by the presiding officer before it begins. If it takes more time than is announced, you can extend the time. And the way you do that is have generally the chair or one of the representatives for the commission will announce in open session that it's being extended for some period of time. And if it requires less time than announced, then you don't start the open session earlier than the stated time. So it's better to underestimate the time than to overestimate the time for that reason. And then you enter the announced purpose of the executive session must be entered into the minutes. So you don't take minutes of the executive session, but the purpose is entered into the minutes for the regular or special meeting. And only persons necessary for the executive sessions are to attend the executive session because it's confidential. If the regular or special meeting that the executive session is a part of is a hybrid or remote meeting, it's important to utilize technological tools to ensure that only those who are necessary are included. Again, because it's confidential, you don't have a situation where somebody could join the executive session through some kind of meeting room or otherwise, because it's a confidential part of your meeting. And so I mentioned there the waiting room situation. So a different concept is a closed session. This is important because it does directly apply to the commission. There are times when you have, for example, appeals where a closed session would apply, and it's different. It's a different type of gathering than an executive session. And so it's very significant. It's not applicable to every type of governing body, but it is applicable to this commission. It's a type of meeting of the commission in which this chapter shall not apply, meaning that the OPMA does not apply. So that all the provisions and requirements of the OPMA do not apply to a closed session because it's outside the OPMA. So that's really important to understand. So the OPMA does not apply to, and closed sessions are allowed related to just very limited types of circumstances, which include quasi-judicial proceedings, which this commission is involved in at times. And so we'll always make that clear to you when that applies. But those are generally situations where you have like an appeal situation where you have named parties in a contested matter, where you have adverse proceedings. So, and it's the portion of the so it could be a portion of a meeting, another meeting, or it could be a meeting of itself that relates to a quasi-judicial matter between named parties as distinguished from a matter having general effect on the public or on a class or group. It also applies to collective this wouldn't apply to you all, but collective bargaining sessions and certain licensing proceedings and other proceedings under the Administrative Procedures Act. But the main one here is to focus on is the quasi-judicial. Again, in the future, as these come up, we will definitely make you aware of which ones are quasi-judicial. Now, turning to another topic, closing this up, minutes. This is a topic that often comes up. So minutes of regular and special meetings must be promptly recorded and open to public inspection. Here, recorded does not mean an audio or video recording of the minutes. It means that there's a record kept of them. So it's the preparation of a written document that constitutes the minutes for the meeting. And as I mentioned earlier, minutes of an executive session are not required, but the purpose of each executive session must be recorded in the minutes of the regular or special meeting that's at issue. And state law does not require that minutes be prepared in a specified format. And this commission, at the end of last year, we talked about having kind of more briefer minutes that are what we refer to as action minutes, because the focus of the minutes is for the commission and the public to know what action basically was taken, who was there when it happened or when it occurred and what was on the agenda and what action was taken. But it can be quite brief. And so the commission adopted an action minutes type process going forward, which I think will be a good way to go. Now, in terms of meeting interruptions and disruptions, this comes directly from the OPMA. What is allowed and what's permissible. So the commission may stop people from speaking to the governing body when they're not recognized by the governing body. In the event that a meeting is interrupted by an individual or individuals so as to render the orderly conduct of the meeting unfeasible and such that order cannot be restored by the removal of the individuals who are interrupting the meeting, the OPMA has a process for addressing such situations. This hopefully would be a very rare situation, but the OPMA does address this specifically and does give you options. Under that process, the meeting room may be cleared and the meeting may continue, or the meeting may be adjourned and reconvened at another location. Final disposition may be taken only on matters appearing on the agenda. Members of the media who do not participate in the disturbance shall be allowed to attend any such session. And finally, the governing body may establish a procedure for readmitting an individual or individuals not responsible for disturbing the orderly conduct of the meeting. So again, hopefully this would be very, very, very rare situation, but it is specifically in the OPMA because it does occur in certain circumstances, and it's important for you all to know what your options are. There's also identification and provisions related to emergencies and remote meetings. So this is very specific to certain circumstances. So if the federal government, the state, or the city declares an emergency, and if the city determines it can't hold a meeting in person, so this case would be the commission, determines it cannot hold a meeting in person with reasonable safety, or members of the public are in attendance because of the or the public are in attendance because of the emergency, then the meeting can be fully remote or have limited physical attendance, because remember, otherwise you need to have a physical location for your meetings. And in this case, the public must have real-time free, at least listening access remotely, and notice of the meeting must include remote participation. So again, this is something for you to be aware of, but hopefully it's not going to apply to this particular commission, but it could, for example, if there is some kind of natural disaster or something. Okay, so in closing here, I want to leave you with 5 key takeaways from this, to kind of reiterate some of the key points that were made. One, a primary purpose of the OPMA is to provide for transparency to the public related to the commission's business. And in the interest of transparency, you may find that the work of the commission is not as efficient as you would like. So that's important to know, that the purpose of the OPMA is not, it's not for efficiency, it's for openness and transparency. And so again, in other circumstances, you may have other commissions that have more than 3 members where they can actually meet in subcommittees to do certain work. You can't do that. So that's not very efficient, but that's the purpose of the OPMA is for you all to, for the public, to allow for transparency to the public for the work that's being done by the commission. And because you only have 3 members and 2 is a majority, that's why that can't be done that way for related to your commission. This training is not only important regarding your role for the city, but it's also a legal requirement based on the OPMA requirements and also the Public Records Act requirements for when what Aaron gets into that. It's important, you know, the difference between a regular and special meeting, which we talked about. It's important for you to be aware of what constitutes a rolling or serial meeting, which we talked about, and also important for you to be aware of how to lawfully use technology in a manner that complies with the OPMA, as we talked about, related to email or even through social media, that you don't have situations where you could have 2 of you having exchange of communications about commission business that could constitute or run afoul of the OPMA. So with that, I could take a few questions now, or again, we can have future further discussions about this, or you can contact me directly. Any questions right now?
Hi, this is Commissioner Knoll. I don't have any questions, but I do want to thank you for that refresher. It's helpful, and I appreciate the level of detail that you went into. Thank you.
Yes, thank you very much, Joe.
You're welcome.
Hi, Joe. This is Andy Pittman. May I ask a question from the public side of it, or is that something that's not?
Yeah, this training is for the commissioners, but hopefully you gain some knowledge about the OPMA by attending. But Commissioner Applegate, do you have a question?
Yeah, I just wanted to say again, thank you for the training. It was very thorough and informative, especially for someone like myself as a lay person. And I don't have any questions at this time. Thanks again.
Okay, thank you all. So with that, I will end my presentation and I will turn it over. So is the screen stop sharing? Yes, okay. I'll turn it over to Aaron Valla. Again, he's also one of my colleagues in the city attorney's office and the government affairs section, who will provide the public records training. And his training is the topic, the range is not as broad as mine, so it will not be as long as mine was.
Thank you, Joe, and thank you, commissioners, for your time today.
Can I stop you this friend? Can we take a couple-minute break?
Yes.
Take a little recess, maybe come back and maybe like 2-3 minutes. Is that all right?
Of course.
Sure.
Thank you.
Is there going to be an opportunity, whether formally or informally, to ask a few questions?
I don't think that there will be today, but if you write to me, I will write back to you, and I can't talk.
Can I at least get
Hey,
everybody?
Sarah, I think the recording is still going.
Okay, we're back on the record. Go ahead, Mr. Ballin.
Thank you very much. So again, thank you, commissioners, for your time today. I'm going to go ahead and share my screen, which is going to be a PowerPoint on the Public Records Act as a refresher. Again, today's presentation is not intended to be legal advice. This is intended to be the refresher and training on the Public Records Act as it applies to the city and the commission. So please feel free to ask any questions. Could someone confirm that you can see the training?
Yes, we see it.
Thank you very much. All right, and I'll get going here right now. So again, my name is Aaron Valla. I'm with the City Attorney's Office, and as we go through, we'll be talking today about the Public Records Act, which is the Washington State transparency law that involves, it's similar in nature to the Federal Freedom of Information Act, which you may be familiar with, but this applies instead to Washington State agencies, including the City of Seattle and including any boards or commissions of a local agency, which applies to your commission here. So what we're talking about in terms of the Public Records Act and the public records in general, a public record includes any writing containing information about the conduct relating to the conduct of government or created in the performance of any governmental or proprietary function. So it's any record that's prepared, owned, used, or retained by an agency. By what we mean by writing in this context is really any form of record, including handwritten records, electronic records, text messages, audio-visual recordings, or really any type of definable entity of like separate record that could be created. This is kind of left open in the statute to address even new technologies as they're coming online. So it's something to be aware of that releases really any type of actual recording or anything that preserves communication is going to be considered a writing for the purpose of this the act. This act was passed again by initiatives in the 1970s as in the wake of a lot of public corruption scandals, as really a transparency law. And this is supposed to be, again, the people of the state have not given up their sovereignty, and the people have a right to understand the workings of government on their behalf. And so this law really provides the ability for any member of the public to request records from a public agency and requires public agencies to respond. So the takeaways that I hope that you get from today's brief training are that the records that you create in the course of your work as a commissioner are public records and may be subject to requests and subsequent disclosure. That notes, recordings, and written communications in furtherance of your work are going to be public records, even if they're going to be prepared on a personal device or using a personal account. This is something where if you have used a personal email account or you're using a personal phone to communicate on behalf of in your role as a commissioner, those records may still be considered public records. We may ask that you help collect them and provide them to the city in order to produce in response to a request for those which those records would be relevant. Personal notes are subject to disclosure, but they may not need to be kept beyond your personal need for them to inform your work if there has not been a request for them. Once there has been a request for records, we do need to preserve them and turn them over, even if you otherwise could have destroyed them. So this is something where once you have notice of a request, if you have responsive records, we're going to need you to hold on to them and work with the public disclosure officer to help facilitate their work. Use of a personal device or account will potentially result in the phone number or email address being disclosed. This is something where if you were emailing with the staff members using your personal email address, that could be then disclosed in terms of in response to a public records request. This is something where some commissions have commissioners in other commissions have decided to create a web email address specifically for the commission work. This both facilitates their work so that all their commission work is in one place, but it also means that their communications, their personal email address that they use for all the rest of their personal life is not something where it's becomes part of city business. In terms of compliance with the Public Records Act, in terms of practically who does what, the public disclosure officer that works with your commission will work to accept requests. These can come in any form. Generally, the city prefers that they come in through a public records portal, but they can really come in by email. If somebody makes a request during a meeting, that can happen, or if they come to the city and make it at the front desk or something of that nature, the city will work to incorporate it into its public records portal and respond to the request. The city acknowledges public records requests within 5 business days as statutorily required. The public records officer will communicate with the requester and clarify requests as needed. Sometimes there's some back and forth where requests are unclear, and in order to help facilitate response to that request. The public records officer also performs and arranges for the search of relevant locations on city systems, like conducting an email search, for instance, or searching preserved files on city devices. They may need to reach out to you as commissioner to help identify terms to use in that search, or help identify subject matters where they may not be directly clear about exactly where records might be kept. The public records officer then reviews the search results for responsiveness and applies any applicable Public Records Act exemptions or other statute exemptions to the documents prior to release to the requester. In terms of commissioners and what your role is in this process, first of all, it's good to be aware that your records may be subject to public disclosure, and that requests can be made in any way, in any type of form. So if you become aware of a request, please do make sure that your public records officer is aware of the request, and that way we can promptly respond to it, statutorily required. If you're not sure if something's a public records request, please do pass it on to your public disclosure officer. They will work to help determine whether that the request is a public disclosure request and how to respond to it. When you are asked to help respond to a request, please provide any relevant information, like in terms of search terms, date ranges, that can help the public records officer really hone in and find out the records to help ensure a prompt and accurate response to a request. And if you are aware of where materials might be kept, or if there's something particularly sensitive for which an exemption might apply, it's always a great idea to flag it. The public records officer themselves will apply any redactions, as opposed to you as a commissioner. However, letting them know of a particular concern can help direct their eyes towards a particular record or particular potentially applicable exemption. And then if you're asked to perform a search of any non-city devices or non-city accounts that you may be using for your commission work, please do that on a promptly, and return any results to the public disclosure officer as appropriate. And and if asked to later on, provide an affidavit that you have completed the search, and that no records were found, or that you have searched all relevant locations. So I did mention that there are Public Records Act exemptions and other statute exemptions. We're not going to go into all of them here, but a couple that might come up in the course of this commission's work are attorney-client privilege. This will cover communications that the commission has with the attorneys from my office, or if outside counsel were hired for some reason. They include any requests for legal advice, or the responses back receiving legal advice in that context. So to the extent that you're formulating a request for legal advice, that would be privileged. To the extent that you were talking amongst yourselves about legal advice that you have, again, being cognizant of the OPMA restrictions on those communications, though those may be considered privileged as well. Work product covers materials that are created in anticipation of litigation or in furtherance of ongoing litigation matters. To the extent that the commission was directly involved in litigation, there could be materials that were asked to be collected or gathered or created in terms of those litigation matters. Those would be covered by the work product exemption. There are also protections for test questions or scoring keys associated with hiring exams or promotion exams within government work. And so this is something that, again, may come up in the course of your work, and may need to be applied to protect the validity of those questions, so that they can be used in further hiring processes without affecting the competition for those positions. This is something where the idea is that if the questions were out there, that everyone would have access to them, that then one person may have an unfair advantage over a person who did not have that information. Similarly, application materials and certain informations in personnel records, such as home address, personal phone numbers, personal email addresses, social security numbers, driver's licenses, and payroll information, payroll deduction information, and emergency contact information also comes out as in terms of exempt. So are also covered by exemptions. There are there are several hundred potential exemptions. Most city business is not covered by an exemption, though, and so this is something where it's something to be aware of, that there are certain information that is exempt, and that the public disclosure officers regularly regularly apply exemptions as appropriate. There's also a deliberative process exemption, which covers policy discussions for ongoing policy discussions that are where people are offering recommendations or opinions. This exemption does not cover factual information, but it does cover to the extent that there are discussions where decision makers are trying to make a decision and they're getting recommendations or opinions from folks. It can protect those recommendations up until a decision is made. Once a decision is made, those materials are no longer covered by the exemption. So in terms of consequences for non-compliance, there is no personal liability. The agency is responsible for PRA compliance. However, if there's PRA litigation, you may be asked to provide testimony or declarations as to your involvement in responding to a relevant request. Where an agency is found to have denied a requester an opportunity to inspect a record or has not made a reasonable estimate of time, and so in other words, delayed its response to provide records to a response to a records request, a court may assess penalties in the amount of up to $100 per day per record. A finding that an agency has violated the Public Records Act will also subject the agency to the requester's costs and attorney's fees. So this is something where the city aims to comply with the Public Records Act, but if there was found to be in violation, there could be significant monetary penalties. Noncompliance can also result in unfavorable media attention, a breakdown in trust with the public and the people being served by the agency, and it can tie up agency resources in a way that takes away from the Commission's primary mission, which is doing the great work that you guys are all here to do. And so it's something that, in addition to wanting to comply with the law, there are many other ancillary reasons why we want to make sure that we're in compliance with the Public Records Act. So the overall takeaways from today's training that I hope you can take away from this brief presentation are that the records you prepare, own, use, or retain as commissioner are going to be public records. This does not mean that every record that you have in your personal life or that the city will be searching your personal phone or personal device. This is something where we understand that the law understands that you have records that are not in furtherance of your work. But when you are working as a commissioner, those records are going to be considered agency business and subject to disclosure. Requests may come to you directly. To the extent that they do, please do provide them to the public disclosure officer as quickly as possible. We want to make sure that that statutory response deadline to acknowledge requests and to set up a response schedule is promptly accomplished. Your assistance might be needed if a request does come into the city for records that you may have to help provide those records or help us identify records in order to respond to a request. And then once a request has been received for records, please do make sure that you preserve any responsive records so that we don't end up in a situation where records are inadvertently disposed of without being provided. So again, thanks for everyone's time today. If you have any questions, please, you can route them either through Council Joe, your Council Joe, and he can refer these, or through your public disclosure officer. For legal questions, you can reach out directly to the city attorney's office, or you can route those to the public disclosure officer, and I'm happy to help advise as those questions come up. If the question is related to a specific request, it's often best to include the public disclosure officer. That way everyone stays on the same page. So again, thank you for your time and for your service. And I know we went a little bit long today. So again, thanks for your patience here. And with that, I'll wrap up the presentation, but it will be made available to you for reference as you'd like. Thank you.
Thank you, Eric. That was very helpful. All right.
This is Commissioner Knoll. I just wanted to say thank you for the presentation, and I appreciate how much practical information and guidance that it provided.
Aaron, it looks like you're still sharing screen.
Oh, great. Thank you very much. I'll try to turn that off here.
Okay.
Apologies for the technical.
There you go.
Okay.
Great.
Thanks.
Thank you. So the next matter on the agenda is the police and fire and police exam unit updates. So Ms. Sade, do you have an update on that? Is she on their call?
Ms. Chamberlain is going to give that
Okay.
report today.
Hi, everyone. This is Amy Jo Chamberlain. I'm an analyst on the Fire and Police Exam Unit. And as Ms. Shealy mentioned, I am going to provide the police exams update on behalf of Rachel Sade, Police Exams Administrator, who was unable to attend the meeting today. So the report is that the entry level and lateral entry exam cycles are both in progress, with testing in the current exam cycle closing on February 7th. The new eligibility registers for both the entry level and lateral entry police officer will be sent to SPD on Monday, February 12th. And on the promotional side, the Police Sergeant's Exam Development Committee continues its work to develop the 2024 Sergeant's Exam. The committee completed its work recently in the review and editing of written exam questions. The written exam will be administered on March 2nd at the University of Washington's Kane Hall. And the development committee has started its work on assessment exercises, and a series of meetings have been scheduled to complete the work. The administration of the assessment exercises for candidates who pass the written will occur on April 6th. And the application filing period for this exam occurred during the period of January 3rd through 17th. And we received 67 applications from officers eligible to take the sergeant's exam. And that concludes the report for the police side.
Great, thank you very much. Sui, do you have a report on the fire department?
I do. Hi, this is Yoshiko Grace Matsui. I'm the Fire Exams Administrator for the Fire and Police Exams Unit. We are in development stage of 3 promotional exams on the fire side, the first being the rank of fire captain. Are currently meeting with our promotional exams committee and also battalion chief. And we just had our kickoff meeting for the start of the development for the fireboat pilot exam. So all 3 of those are currently in development with committee meeting regularly. We also had our open application period around the same times as the fire promotional exam, or the police promotional exams, excuse me. And currently I have 39 folks who have signed up for the captain's exam, 12 people who have signed up for the battalion chief's exam, and 4 people who have signed up for the pilot's exam. I will note that I'm still in the process of checking their exam eligibility, so that number may decrease if they're found that applicants don't meet the minimum requirements to take the test. That doesn't happen very frequently, but it may affect 1 or 2 people. I'm waiting to get back information from our workforce analytics and reporting unit before I can move on with communicating with those candidates. And as a big update, we have started the process of meeting to develop the firefighter open application testing period for fall of 2024. And that test spans across 2 fiscal years and calendar years. And so we begin the open application testing process typically in the first week of October in the year that we do testing. And that concludes usually around 10 weeks later. These dates are a bit squishy, they're tentative. And then typically for a staffing and cost related resources, the oral board section for the civil service testing process for firefighter typically happens in January, February of that following year. We are in the process of securing space to hold those in-person oral board for firefighter, and hopefully we'll have a contract signed soon. And that is the extent of all of the things that we are working on in fire exams.
Thank you very much. The next item is on staffing numbers.
Oh, yes, I have that report. This is Andrea Shealy, and thank you to the fire department for providing this information about the Seattle Fire Department. Their current staffing is for budget pockets, they have 1,108. Their sworn employee count is 998. The year just began, so they have 0 appointments so far in 2024, and 5 separations, which include 2 resignations and 3 retirements thus far in 2024. Appreciate that data being provided to me. For the Seattle Police Department, these numbers are accurate as of the end of 2023, but their staffing pockets, that's individual positions, sworn was 1,106. 971 of those are occupied by an employee. And I do not have numbers year to date for appointments or separations from the police department to report today.
Thank you. The next item on the agenda is case status report, Ms. Sheehan.
Sure, let me give just a super high level budget.
Oh, I'm sorry.
It's not even a report. The report is I do not have the year to date expenditures for 2024. That data was not available to me as of this meeting. But we are working on I'm sure our budget finance folks are working on getting that uploaded into our various systems so that it will be accessible to departments. And we're just launching our work with the city budget office for 2025, 2026 biennium budgets. And I'm sure it is no surprise to anyone here that the City of Seattle's general fund is under considerable stress. So we will just see where that goes. And I'll be happy to give reports as we move through that process. Departmental work, you know, you're looking at a lot of it. We continue to oversee and direct the fire and police entry level of promotional exams for the civil service system. We also have a couple of disciplinary appeals, which I'll give a report about in a minute, for both the civil service and the public safety civil service systems. And well, that is the highest level and probably an adequate report at this point, considering how long this meeting has been going. And so I'll be happy, Commissioner Gray, to move on to the case status report next.
Yes, thank you.
Thank you. The only appeal that is pending before the Public Safety Civil Service Commission at this time is Willis v. SPD. That is case number 23-01-004A. And your materials are available in the packet at pages 9 through 14. Actually, they start at page 11, it looks like. Case status report starts at page 9. And the Willis matter is a disciplinary appeal of a suspension. Officer Willis is not pursuing his a grievance through his collective bargaining agreement on this matter, so the commission very likely will hear the appeal. And the status is that we've scheduled a pre-hearing conference for me to preside over on February 2nd, so next week, where I will hear from the parties and try to determine the scope of the appeal. That is the only part of the case status report for today.
Great, thank you very much. So the next item on the agenda is old and new business. I'm not aware of any older business, but do any of the other commissioners have any old or new business that we need to discuss? All right. That seems to be the end of our agenda. So unless there's anything else, I would move that we adjourn.
This is Commissioner Knoll. I'll second that.
Okay. Any discussion on that from anyone? Okay. So all in favor of that motion, say aye. Aye.
Aye.
Aye.
All right.
Oh, I'm sorry to interrupt.
Okay. Never mind.
Golly, I'm glad that I saw this before the end of the meeting, because I see a mistake in the regular schedule that you all voted on. The February meeting is incorrect. We're actually going to have a special meeting on February 7th, which we've already ascertained with all of your calendars. In this regular meeting schedule, it is reflected as the 13th. But we've scheduled a special meeting to do some work together as a commission. And it's going to be a longer meeting as well. So could Joe, what's the proper procedure here?
I would suggest that the commission move to to amend the previous schedule that was adopted accordingly based on what you just described, and then to vote on that change.
Okay, so I will move that we amend the meeting schedule that we previously adopted to change the Tuesday, February 13th meeting to.
You know what? Okay, I do apologize. I think I punched you at the end of this meeting. That is incorrect. It is a different meeting on the 7th. I think I'm thinking of the Civil Service Commission. Forgive me, forget everything I said, and I apologize.
All right, never mind again. So we're back to, so I think I'd made a motion to adjourn. Commissioner Knoll had seconded that. We had voted on that. And so I think we stand adjourned. 11:42. Thank you all very much.
Nice to see everyone. Thank you.
Thank you. Oh, sorry about that.